साथियों नमस्कार। धर्म जीवन चैनल में फिर एक बार आपका स्वागत है। मैं लेकर आया हूं आज 25 मार्च मंगलवार अहमदाबाद गुजरात हाई कोर्ट केस के फैसले की जानकारी, जो आज की कार्रवाई की जानकारी। फैसला तो 28 मार्च के लिए सुरक्षित हुआ है। सबसे पहली बात, आज सभी का सुबह से बिल्कुल ध्यान यही था कि जो गुजरात हाई कोर्ट में हमारे पक्ष में निर्णय मिले और जिससे लगभग 90 वर्ष के परम पूज्य संत श्री आसाराम जी बापू को उचित उपचार की अनुमति, पूरी अनुमति मिल जाए, इसके लिए सब का संकल्प था। और सबसे बड़ी बात ये भी है कि अगर हम सभी इस चीज़ को जानते हैं कि वो अधिक उम्र में अगर ऑपरेशन हो, किसी के हाथ की हड्डी टूट जाए, तो डॉक्टर कहता है कि थोड़ा जुड़ने में टाइम लेगा, क्योंकि आपको पता है ना, उम्र हो गई है। ऑपरेशन में भी डॉक्टर कहता है घाव भरने में टाइम लेगा, क्योंकि उम्र हो गई है। यहाँ पे तो परम पूज्य संत आसाराम जी बापू की उम्र लगभग 90 साल के करीब हो रही है। ऐसे में ऑपरेशन तो संभव है ही नहीं, और औषधि इंजेक्शन भी शरीर झेल पाए, ये भी संभव नहीं है। इसके लिए एक ही रास्ता है, आयुर्वेदिक उपचार। और आयुर्वेदिक उपचार के लिए पहले अनुमति मांगी थी, तो माननीय सुप्रीम कोर्ट ने 31 मार्च तक का समय दिया था, जो लगभग पूरा होने को है। उससे पहले का अनुरोध था, तो सभी की इच्छाएं थी। और आज कुछ ये जरूर आज हमारे वकील द्वारा, एक युवा वकील थे, युवा जोश, युवा होश और युवा समझदारी थी, उन्होंने बहुत अच्छे से अपनी बात को रखी। अगर मैं आपको वीडियो भी दिखाऊंगा, आज के बहस का लाइव वीडियो जो है वो भी मैं आपको दिखाऊंगा चैनल में। लेकिन सबसे बड़ी बात क्या है कि सरकारी पक्ष के वकील ने बहुत सारे ऐसे प्रयास किए कि जिससे बापूजी को इलाज के लिए स्वतंत्र अनुमति ना मिल पाए, जिसमें कुछ चीज़ें उसके द्वारा कही गई जो है वो मुझे लगता है कि एक व्यक्तिगत सावधानी की भी चीज़ है। जैसे सरकारी वकील द्वारा बात उठाई गई कि इलाज के लिए बापूजी अनेक स्थान पे तो गए, लेकिन फॉलोअप नहीं लिया। ये बड़ी चीज़ है कि फॉलोअप की जो बात आ रही है, तो उसमें एक चीज़ ये अवश्य है कि आयुर्वेदिक जो पद्धति है, जैसे आप जानते हैं केरल की इलाज पद्धति, उनकी औषधि अपनी कुछ चिकित्सा पद्धति, रिसर्च होता है उनका, कुछ अलग है। हरिद्वार आ जाइए तो कुछ अलग है, अन्य स्थानों का अलग अलग, क्योंकि सब वैद्यों का एक उनका अपना अनुभव का निचोड़ है। तो आयुर्वेदिक उपचार के उद्देश्य से परम पूज्य संत श्री आसाराम जी बापू जोधपुर से अहमदाबाद भी गए, वहाँ पे भी अच्छे चिकित्सक से पूरा जांच कराया, उनका सलाह, विचार, ओपिनियन रिकॉर्ड लिया, जो कोर्ट में सबमिट है। उसके बाद में जैसे लोगों ने बताया कि इंदौर में भी अच्छे चिकित्सक हैं, तो इंदौर भी गए और वहाँ पे भी इलाज के लिए उन्होंने पूरी जाँच कराई और वहाँ भी सलाह लिया। फिर जानकारी में आई कि उज्जैन की एक अपनी चिकित्सा पद्धति है, विशेष है, तो गुरुदेव का उज्जैन भी जाना हुआ और वहाँ पे भी उन्होंने जांच के लिए जो भी है पूरा निर्णय लिया उसमें। और एक सबसे बड़ी बात है, अगर आप देखेंगे तो सभी जगह है कि जो रिपोर्ट है उसमें यही बात लिख के आई है कि उनका स्वास्थ्य जो है वो कठिन स्थिति में है, मतलब आप अच्छा स्थिति नहीं बोल सकते, और उसमें रेगुलर फॉलोअप की भी जरूरत है। मतलब कि गुरुदेव का इलाज जो होगा, जैसे हर हफ्ता 15 दिन में जा करके उसे वहाँ के चिकित्सक को दिखाना, इलाज में क्या हुआ, आगे क्या औषधि लेनी, वही ठीक है कि बदलना है, वो सब चीज़ें। तो ये सरकारी वकील ने बात उठाई थी कि कई जगह तो गए लेकिन फॉलोअप नहीं लिया है, कि भाई कहीं गए दिखाया बता, लेकिन क्या आगे चिकित्सा पद्धति ली। तो फॉलोअप का हमें भविष्य में ध्यान भी रखना पड़ेगा कि हाँ, इलाज तो आवश्यक है लेकिन फॉलोअप भी प्रॉपर है। एक तो वो चीज़ जरूरी है। दूसरी चीज़ कि खाली वही नहीं, देखिए इस उम्र में और इस अवस्था में परम पूज्य संत आसाराम जी बापू स्वतंत्र हैं कि वो अन्य स्थान पे भी चिकित्सा पद्धति क्या उनके शरीर के अनुरूप अनुकूल रहेगी, उसकी जानकारी ले सकते हैं। जैसे दिल्ली में एम्स है, एम्स ऑल इंडिया इंस्टीट्यूट ऑफ मेडिकल साइंस आयुर्वेदा, जिसका माननीय प्रधानमंत्री नरेंद्र मोदी जी उद्घाटन करके गए, बहुत अच्छी इसकी भी पद्धति है। तो मैं तो व्यक्तिगत तौर पे भी निवेदन करूंगा कि एक बार गुरुदेव को एम्स आयुर्वेदा दिल्ली के भी यहाँ पे, क्योंकि प्रोफेसर लेवल के और सरकारी मान्यता प्राप्त चिकित्सक हैं और बहुत बड़ा ये एक विश्वविद्यालय की तरह यहाँ रिसर्च होते हैं। तो यहाँ भी गुरुदेव को दिल्ली में भी निवेदन किया जाए गुरुदेव से कि वो दिल्ली आएँ और यहाँ चिकित्सा पद्धति के लिए ऑल इंडिया आयुर्वेदा के भी चिकित्सा पद्धति का जानकारी लें कि गुरुदेव के लिए अनुकूल क्या है। फिर और हमने जांच पद्धति के बारे में हरिद्वार का भी सुना है, वहाँ भी बहुत अच्छे अच्छे चिकित्सा पद्धति है। और पहाड़ों में तो आप जानते हैं कि सारी जड़ी बूटियाँ हिमालय के सुदूर क्षेत्रों में ही बसी हैं। तो उसमें आपका ये है हरिद्वार हो गया, आगे जो स्थान है वो ऋषिकेश हो गया। इन स्थानों पे भी बहुत अच्छे अच्छे आयुर्वेदिक चिकित्सा पद्धति है। तो हम सभी साधकों का ये संकल्प है कि गुरुदेव जहाँ उनको अनुकूल मिले, जहाँ अच्छा स्वास्थ्य मिले, वहाँ पे पूरी तरह से ठीक हो जाएं। और सबसे बड़ी बात अगर आप देखें तो अपने वकील द्वारा ये बात भी रखी गई, इतनी सारी बीमारियां, एक तरफ से आप सुनेंगे वीडियो में कि कितनी बीमारियां सही में है और उसके बाद भी संत अपने शरीर को कैसे संभाले हुए हैं। इस अवस्था में तो कोई शायद चल फिर भी नहीं सकता, जितनी बीमारियां हैं। हार्ट में 90% ब्लॉकेज के 3 ब्लॉकेज हृदय में है। बोलो, सोचो आप कितनी पीड़ा होती होगी। फिर भी संत ये कहते हैं, संत अपने जीवन को भी कष्ट में रख के भी लोगों का हित हो, मंगल हो और समाज में किसी को पीड़ा न हो, उनको दुखी देख के, बीमार देख के, इसलिए वो दर्द सह के भी मुस्कुराते रहते हैं। और एक चीज़ मैं कहूँ कि अगर आप सरकारी वकील ने तो एक ये भी बात उठाई थी, वो वीडियो में इंग्लिश में पूरा उनका डिस्कशन है, आप समझ जाएंगे। जो नहीं समझेंगे उनके लिए मैं समझा रहा हूँ कि सरकारी वकील ने बोला कि भाई इस उम्र के तो बहुत सारे कैदी हैं और आयुर्वेदिक इलाज में तो इतनी जल्दी तो होगा नहीं, इसमें तो बार बार समय लगेगा। तो ऐसे तो फिर और ये भी आगे और समय मांगे, और भी कैदी कह सकते कि हमको आयुर्वेदिक इलाज के लिए अनुमति दी जाए, और ऐसे तो लोग मांगेंगे। तो उसमें बहुत अच्छा हमारे वकील द्वारा जो बहस की गई चतुराई से, उसने और भी उन्होंने सरकारी वकील ने बात रखी, क्रॉस किया है, लेकिन हमारे वकील ने चतुराई से बात रखी कि श्रीमान जी, आयुर्वेदिक और यूनानी पद्धति जो सरकार से मान्यता प्राप्त है, और जो सरकार से मान्यता प्राप्त है उस पद्धति को बिल्कुल ना लें या उसकी जांच ना कराएं, ये बात बिल्कुल अनुचित है। और ये चीज़ मुझे लगता है कि जज साहब ने भी बोला, ओबलाइज किया है और कहा है, बल्कि उन्होंने बात बोला कि हाँ पंचकर्मा पद्धति होती है इलाज की। तो हमारे वकील द्वारा कहा गया कि इस इलाज के लिए पंचकर्मा की जरूरत है, पंचकर्मा में रेगुलर फॉलोअप की जरूरत भी है, जिसके लिए जहाँ तक मुझे समझ आ रहा है कि 9 महीने का समय मांगा है। बाकी वीडियो आप देख समझ जाएंगे और उचित है कि होना चाहिए। और एक चीज़ मैं बताऊं, अभी बात ये है कि इसमें एक वकील साहब अंकल जी भी थे, उनको मैंने देखा, वो जहाँ तक मुझे लगा फरियादी लड़की की तरफ से आए थे। उन्होंने भी कोशिश करी कि सरकारी वकील ने भी, फरियादी लड़की के वकील ने भी, कि रोकने की कोशिश करे कि इलाज की अनुमति ना मिल पाए। लेकिन कहते ना जैसे हमारी भाषा में कि टांग अड़ाने की कोशिश की। लेकिन हमारा जो युवा वकील थे एक धन्यवाद के पात्र हैं, और लीगल टीम भी धन्यवाद की पात्र है कि जो सही, मतलब ऐसे ही चाहिए, जो समय अनुसार अपनी बात को रख पाया, वो उन सब चीज़ को लांघते हुए बड़ी चतुराई से अपनी बात रखा है उन्होंने। और यहाँ तक कि जहाँ तक पूरा सुन के मुझे लग रहा था कि हाँ ये पॉजिटिव रिजल्ट ही आएगा, क्योंकि जज साहब भी बाद में कह रहे थे ओबलाइज हाँ मान रहे इस बात को, तो वो चीज़ मुझे एक अच्छा लगा। और एक चीज़ मैं कहूँ, हम साधकों के हिस्से में तो बस यही आता है कि संकल्प खूब करें कि गुरुदेव का जहाँ भी उचित इलाज हो वो पूर्ण रूपेण स्वस्थ हो जाएं। और जो भी इलाज के लिए टीम है, फॉलोअप बहुत अच्छा रहे, क्योंकि देखिए गुरुदेव का आगमन जहाँ भी होगा इलाज के उद्देश्य से होगा। इसीलिए हम ये ध्यान रखें जो भी है कि इलाज कार्यक्रम के लिए नहीं है। इसलिए संदेश एक दूसरे को देते समय भी शब्दों का उचित चयन रखें, क्योंकि सावधानी हटी दुर्घटना घटी, ये चीज़ हो सकता है। और ऐसे मुझे एक निवेदन ये भी है कि कहने के लिए तो बहुत कुछ कहा जा सकता है, लेकिन हम अच्छा सोचें, अच्छा संकल्प करें। और मेरे मन में भी ये भाव है कि हम सभी एक पॉजिटिव, एक कहते हैं सकारात्मक विचार लेके चलें कि 28 को बहुत अच्छा हमको रिजल्ट मिल जाएगा गुजरात हाई कोर्ट से। और उससे पहले मुझे लगता है हमारी लीगल टीम जोधपुर हाई कोर्ट में पहले एक्टिव हो जाएगी, ताकि क्योंकि 28 के बाद मुझे जहाँ तक लग रहा है, आप 30 तारीख को रविवार है, 29 को शनिवार है, 31 को भी शायद छुट्टी है वो आपके ईद की, तो लगातार छुट्टियाँ। 28 का समय एकदम बड़ा कह सकते हैं आपकी बॉर्डर लाइन का समय है, उसमें चूक ना होने पाए, नहीं तो फिर वो होगा कि 28 दिन का 29, 30, 31 के बाद में फिर कुछ भी ऐसा हम क्यों सोचें। तो मुझे लगता है कि लीगल टीम भी बहुत एक्टिव होके जोधपुर के लिए भी पहले से तैयारी कर लेगी, ताकि 28 को इधर आए, उस वहाँ पे जजमेंट की बात हो सके। और आज की जो बहस हुई है उसमें और भी कई सारी चीज़ें अच्छी है, आपको अच्छी लगेंगी और आप बहस ज़रूर देखेंगे। और एक चीज़, धन्यवाद, आप धर्म जीवन चैनल 5,500 अपने साधक भाई बहन, और भी साधक ही नहीं, इसमें मेरे बहुत सारे अपने ऐसे क्लाइंट भी हैं जो सनातनी हैं, भले गुरुदेव से नहीं जुड़े, सनातनी हैं, वो भी बहुत जुड़े हैं। और आप बिल्कुल अपना परिवार धर्म जीवन का बढ़ाते रहिए, चैनल जरूर सब्सक्राइब करिए, औरों से भी कराइए, ताकि सबको उचित जानकारी मिल जाए। और निवेदन यही है कि शायद नेगेटिव कहने या सुनने से कुछ होगा नहीं, सकारात्मक सोचें, सकारात्मक की प्रार्थना करें, सकारात्मक संकल्प करें, और हम सब संगठित होकर सकारात्मक करें, ताकि आगे गुरुदेव को पुनः रेगुलर बेल और निर्दोष रिहा होने के मार्ग पे हम आगे बढ़ सकें। आइए आप ये वीडियो देखिए।
In connection with the criminal appeal which is pending before your lordships, Lord, I just want to show, Lord, that we had gone to the Supreme Court, Lord, if your lordships have, Lord, page 17, because this application is filed pursuant to liberty reserved by the Supreme Court, Lord, if your lordships have, Lord, page 17 for a minute. Page 17. May I read? Page 17. We have already made it very clear by our earlier order dated 13/12/2024 that we are not inclined to consider the plea on merits, but only on medical grounds. So merits, my lord, is not to be argued. Then, my lord, I will skip the submissions made by either parties. My lord, if your lordship say, my lord, the last page on page 18, last para on page 18. As stated, we are not inclined to go into the merits of the case. The medical condition of the petitioner is not in dispute. Now, this line is important. It is the concern of the state and this court to take into consideration the health condition of the petitioner convict. In such view of the matter, we have no hesitation in holding that the petitioner does require interim bail on medical ground. The appeal is also of the year 2023. There is also some suggestion of lifestyle changes. We have also taken note of the medical records pertaining to the petitioner and the fact that he was given periodical treatment outside the prison. Hence, we deem it fit to grant bail to the petitioner on medical ground till 31st March 2025. This order is passed subject to the condition that the petitioner shall not meet his followers in the group. There shall be 3 security personnel in the form of police officers to be present in the vicinity of the petitioner. We make it clear that the police personnel will not interfere with the petitioner's medical treatment, his meeting with any individual, and in a normal or lawful conduct. We further make it clear that the observations made in the impugned judgment on merits will not have any bearing on any future proceedings, including the criminal appeal, which is pending before the High Court. Liberty is also given to the petitioner to approach the High Court for any further need on this ground. So, on this ground is medical ground, because the Supreme Court has said in the first line that there is no question of merits. We have rejected earlier. So, now this is only on medical ground. So, liberty to approach the High Court for any further need on this medical ground. Now, my lord, I just want to show, my lord, 2-3 things, my lord, if your lordships have, my lord, because this will be important. What did the Supreme Court consider, my lord? Page 157, if your lordships have, page 157. This is the list of hospitalizations of the applicant from 8/11/2023 to 21/2025. Not doubted, because the Supreme Court itself has come to the conclusion this is a fit case, at least for interim bail up to 31/3/2025, looking to the medical condition. Now, what was placed before the Supreme Court? This list of hospitalizations on page 157, 8/11/2023 to 21/2025. Now, important here, my lord, was page 34. There is a report of All India Institute of Medical Sciences, Jodhpur, 2/2/2024. My lord, where there is an observation by AIMS in para 5. Since the patient is having IHD NSTEACS with CAD, that is coronary heart disease, patient belongs to high risk category. Now, my lord, all this, as I said, all this was placed before the Supreme Court. Supreme Court obviously thought and opined that this is the fit case for bail till 31/3/2025. Now, my lord, what happened after 7/1/2025? Because that matter was over. Supreme Court ultimately not said that you approach the High Court. My lord. Now, for that, if your lordships have not paid, two things I want to show, my lord. MGM, because these are the reports of MGM Medical College, Indore and other associated hospitals. If your lordships have page 175, two documents, 19/2/2025 and the other is on page 198 of Sri Vaishnav Diagnostic and Kidney Center, 20/2/20, sorry, page 175. Page 175. Now, my lord, there, if your lordship, this is not dated 19/2/2025. Obviously, my lord, this, as I understand, my lord, this, these reports, your lordships are asked the learned PP to verify whether these reports are what they say. So, my lord, obviously, my lord, that will be told to your lordship, my lord. Page 176, if your lordships have, my lord, the advice which is tendered by the doctors. Page 176, my lord. I'll just read, my lord, there is the treatment is suggested, and then, my lord, the page 176 mentions, my lord, requires, advises, four things. Requires specialized nursing care and close monitoring, regular visits to physician, cardiologist, avoid undue excretion and stress, regular follow-up with endocrinologist and nephrologist. These are four things which are mentioned, my lord, in the report of 19/2/2025 after the Supreme Court's order, my lord. After that, if your lordships have, my lord, page 179 also, the suggestions, Dr. Shiv Sharma, Professor, Department of Medicine, page 179.
तैयारी पूरी नहीं है इसकी.
The suggestions are to continue as advised by endocrinologist, cardiologist, internal physician, neurologist, orthopedician, strict low-calorie diet explained in detail, in view of frailty, prolonged steroid use, age, multiple comorbidities, and frequent falls. He is advised assistance in walking. He will need prolonged treatment with regular physiotherapy, nursing assistance, and frequent follow-ups under various specialists. Needs to restrict fluid intake to correct hyponatremia. Needs daily weight and monitoring to optimize fluid balance. Will add so-and-so after investigation. Can consider so-and-so shows osteoporosis. So this is MGM Medical College, Indore, my lord, 19/2/2025 in great detail. After this, my lord, because, my lord, since the applicant is suffering from multiple problems, page 198 is, my lord, a report of 20th February 2025 of Sri Vaishnav Diagnostic and Kidney Center, page 198. Page 198. And there also, my lord, the advice is tendered in Hindi. Page 198. This is 20th February 2025. Three is important, my lord. विभिन्न गंभीर व्याधियों के हिस्ट्री होने की वजह से वर्तमान स्थिति को ध्यान में रखते हुए दीर्घकाल तक चिकित्सा की निगरानी में रहे. On page 198, my lord, item 3. One is आहार लघु सुपाद्य आहार. So this is again, my lord, a report of Diagnostic and Kidney Center, page 198, my lord, dated 20th February 2025.
खुद क्यों पढ़ रहा है मूर्ख, अपना तैयारी पहले.
And then, my lord, I believe there is an additional affidavit filed which starts on page 214. If I'm not. What is 216? There is an additional affidavit filed, I believe, additional papers, 214.
And the 213.
Oh, I'm sorry. It ends at 213. Doesn't. No, okay, no. Fine. Can I? Two copies, right? छह तरीके से हमारे पास है सर
तैयारी कमजोर है बेटा।
This shows, if your lordship said 218, 219. This is the current treatment he's undergoing.
बहुत गलत बेटा, बहुत गलत तैयारी है तुम्हारी।
Sorry, it's 218. Sorry, yes.
बहुत गलत तैयारी है।
Now, this is the current treatment that the applicant is undergoing. If your lordship said because since the Supreme Court has mentioned that there will be 3 police personnel, your lordships will see in the last column also signature of the police officer on duty, monitored by so and so, signature of the police, and this is what he's undergoing. And that is why we have filed this application, because the doctors are of the firm opinion that the applicant requires Panchakarma, which is a 90-day course. Panchakarma therapy, which is a 90-day course. There will be some suggestions where it can be, they will argue that ultimately you are adamant or you don't want to undergo surgery, operations, There my submission will be that he is 86-year-old and few people in this world, after the age of 75, 80, they will sustain an invasive surgery of any kind. Even bypass is not possible, because probably after 75, 80 minutes not possible. So in any case, this is what is advised, but this is just to show that this is what he is undergoing at present. And obviously, during this, after 7-1 or even before that, there has never been any breach of any condition. Two more things, page 199. If your lordships are page 199. I have said this in my application as well, This is a special campaign for old prisoners and terminally ill prisoners, A campaign started by the National Legal Service Authority. And if your lordships have page 202, this is again, this is obviously, it's a little general and objective is this, But the fact is that, when you become a convict or when you are a convict, you don't give up all your rights under the Constitution, Yes, understand that your rights will be truncated because obviously there's going to be detention, jail time. But the core rights, they will stay with you. So if you require treatment to keep yourself healthy, then obviously that is a right which is a part of Article 21, and therefore that right can be sought by a convict. There is, because the charge is grave and I am doing lifetime in jail, that doesn't mean that, if death comes, death will come forever. If death comes, it has to be hastened. if it can be prevented, if it can be delayed by a good treatment, by a treatment which I require, then the submission is that this convicts under our constitution do have this right. Now, having said that, one more thing on the aspect of the multiple, as I said, there are multiple assessments done here. So, that in my application also we have mentioned that nephrologist, cardiologist, endocrinologist, we have the opinions and the advice and the reports from all these specialists. Where all of them at least will not have a common ground that this, yes, it is a fatal condition. The situation or the health of the applicant is not good at all. And where I mentioned about the Panch Karma, if your lordships have page 216 again, 216 and 217, that is what the experts from Dhanvantri Ayurvedic Mahavidyalaya Chikitsalaya Ujjain, if your lordships have that, 214, 216. And 217. This is exactly, this is the, it's a part of the additional affidavit or document file, where they have advised that a comprehensive 90-day Panchakarma therapy program, and this regimen includes 3 sittings of 15 days each, with 15 days breaks in between, alongside 6 sessions of leech therapy administered weekly. And this treatment actually has begun on 18th March 2025 under the supervision of Dr. Arun Tyagi. So, to sum up, my submission is that this application be considered for 2-3 reasons. One, Supreme Court has obviously granted me liberty to approach the court for raising this ground. I am not saying that your lordships have to therefore only allow it. I am not saying that, but liberty is given at least, because it can be, if I straight away come to your lordships, it can be argued that no, there is no question because the SOS is already there, rejected on merits. But the fact is that I did go to the Supreme Court. Supreme Court found it to be a fit case for grant of bail on medical ground till 31/3, and the Supreme Court said that if you have any additional need on medical ground. Which means, the Supreme Court obviously has seen all these documents which were filed, and if I am able to convince your lordship that I may be allowed to undergo further therapy which can really improve my health, then only because the charges are grave, it's not that you have to the state, not the state in that sense, but the administration will not tell me that sorry, because of the charges you have no rights, even if your situation and my health can be ameliorated. So, Supreme Court's liberty. Second, as I said, all the experts, because it's only one expert, the cardiologist, as I said, nephrologist, endocrinologist, all the experts have at least one common ground, and no one says that he's okay or he's doing quite well or he will improve. The condition is quite critical. That is at least one common ground. Thirdly, as I said, these reports are after 7/1/2025. All the earlier reports have been considered. That's why Supreme Court said that yes, we will grant you up to 31/3. I have placed additional reports after 7/1/25 with a view to show that this is what is assessed by the doctors and the treatment is also on. And fourthly, as I said, that the core rights of a convict remain. And if your lordships are therefore, apart from the merits, because I'm not arguing the merits at all, if your lordships are convinced that yes, this, because ultimately everything is an experiment, this experiment should be allowed to my client with a view that his health can improve, then my submission is, the lordships may consider this, for the period that is asked for, or a shorter period as your lordships deem it fit, on medical ground. I'll oblige.
We have the order of Supreme Court.
अब सरकारी वकील खड़ा हुआ शायद ये कि लड़की का वकील है.
Noted by the apex court. Function of the state is also noted. So it is not that we are not insensitive about the health of the corporate. But after considering all the medical records which are placed at page number 157, which was placed before the Honorable Apex Court as stated by my friend, about his visit to various hospitals from the prison. There, since November to January, the
कैसे कट गया?
hospitalization was of total 141 days as per their own case, and not less than around 15 times he was required to be taken in case of emergency. That is how the picture was there when Apex Court had considered his interim bail on medical ground only up to 31st March. So considering emergency situation and hospitalization of 141 days, Supreme Court had thought it fit that let him be granted interim bail for a period of 3 months, that is 7 January up to 31st March. And thereafter, court had granted him a liberty to approach this court for any further need. Therefore, he will have to show the need that for extension of interim bail on medical ground, the need is very much required to be pointed out before this Honorable Court. And therefore, at page number 158, Annex D, an index is placed at where he had taken treatment after granting interim bail from the Apex Court. Now, there are 5 hospitals they have named. Now, first hospital is AIIMS Indore. Now, there the certificate which he had placed, AIIMS Jodhpur, I am sorry, not Indore, AIIMS Jodhpur. At page number 164. And at page number 165, subject to what my learned friend had said, because paucity of time we could not verify this certificate. 165, there is no sign of any doctor. And advices which is given is lifestyle modification, avoid extreme weather temperature, continued ADMT, nephrologist, gastrologist, menstrual review, and tapping. That is what the advice which is given. So first about AIIMS Jodhpur, which is unsigned certificate, where it appears that he had went on 28th January 2025 for once. No other paper except 28th January 2025. So one day he had, as an OPD, went to Jodhpur A. That is how it reflects.
Yes, sir.
Thereafter, page 167 is a certificate of an Ayurvedic doctor.
ये कहना क्या चाह रहा है?
Page number 160, my lord, sent them. Paragraph 1.
64 of this. Please.
But this is the only doctor at paragraph number 1 who states, may I read my lord?
Page. अच्छा page.
So on 28th January 2025, he visited his Ayurvedic clinic. 29th ના રોજ સર્ટિફિકેટ આપે અને અરજદારની છેલ્લા 4-5 વર્ષથી સારવાર કરવામાં આવે. હૃદય, ડાયાબિટીસ, પ્રોસ્ટેટ, થાઇરોઇડ, માથાના દુખાવા જેવી અલગ અલગ તકલીફ હોતી જેવા આયુર્વેદિક પદ્ધતિથી સારવાર કરવામાં આવે. પીડીએફ સર્ટિફિકેટમાં લખેલ વિગતો મુજબ લખાય છે. આપણી ઉંમરના કારણે સાથે કોઈ મજબૂત ફરક વ્યક્તિ આવશે જે નિવેદન આ સાથે સામેલ છે. So this is the only Ayurvedic doctor who prescribed this. Thereafter, minor 93 paragraph 2, 3 and 4 are the statements of various doctors where this convict had visited for 1 day on 29th January. So after release from 7th January till date, once he had visited to one Ayurvedic doctor, that is on 28th January. Thereafter, he had visited to Selby Hospital at Ahmedabad on 29th January. And thereafter, he had visited to Indore MGM Hospital on 19th February. And all those doctors' statements, the crux is that he had not came again for the purpose of follow. Visited once, but not came again for the purpose of follow. That itself shows that there is no need now. If at all person is suffering, then he will act as per the doctor's advice. And he will take the follow-up treatment. Now here I made a statement of MDM Hospital, namely Dr. Vaibhav Srivastava. 19-25 ના અરજદાર આરોપી સારવાર અર્થે તેમની પાસે આવેલા 19-25 ના MCM મેડિકલ કોલેજ ઇન્દોર એન્ડ સો લિટર હેડ ઉપર તેઓ દ્વારા એમના સ્વાસ્થ્ય અક્ષરમાં સાહિત્ય પ્રિસ્ક્રિપ્શન લખી આપેલ છે. વેરીફાઈ કરેલ છે. 19-25 ના અરજદાર આપે તેઓના તપાસ થયા એક જ વખત તેઓ તેમને મળેલ છે. પ્રિસ્ક્રિપ્શનમાં લખી આપેલ વિગતવાર સારવાર કરેલ છે. અરજદાર આપે રોજિંદા જીવન મદદની જરૂર છે કે નહીં તે અંગે અન્ય ડોક્ટર અભિપ્રાય લઈ શકાય તેમ અરજદાર સલાહ પ્રમાણે જરૂરી ટેસ્ટ રિપોર્ટ લઈને ફોલોઅપ માટે આવેલ નથી. That નિવેદન of doctor is also attached, my lord, with this compilation. So this is how I would respectfully submit that if at all person is having medical requirement, rather a further need is liberty reserved in favor of the convict by the apex court, then he will act as per the advice of the doctor. And considering this, as he had not acted as per the advice of the doctor in terms of taking follow-up treatment, it indicates that there is no further need. But 218 and others are recently given, my lord, which were not subsequently it appears that it has provided. They are not even rather put by way of affidavit. It appears that simply these certificates are placed. Here, my two one thing, rules of my son back walking. Milos may appreciate one thing from their time. He is a convict. Now, my learned friend is right that basic concept is, but there is always reasonable restrictions. Convict will say that I also, rather I may not say so, but there reasonable restrictions are always there when he is in the category of convict. And on merits, bail application is not considered by the highest court of law. So therefore, all this is required to be in the backdrop of further need. Now, need cannot be an Ayurvedic treatment. He can very well, which will last for all life to come. Ayurvedic treatment will not end in near future. Therefore, a basic right to treatment would be not only allopathy, but the treatment, yes, no, but the treatment which is faster and which can recover him in near future. Now there he cannot choose that I want to treat myself in XYZ manner since he is convict. Otherwise, all convict we say that I want to take an Ayurvedic treatment, release me on bail, and it will last for all times to come. This is what my submission is. Therefore, under a reasonable restriction criteria, he cannot choose that I will go for this Panchkarma treatment, which will last for 90 days, which for an interregnum period of 90 days, which court had granted him, he had never availed of. And only on 18th, after last date, 18th March, he went to this hospital. And on 19th, placed on record this document. So therefore, my lord may appreciate that the convict's right, no dispute. State's concern, no dispute. But all requirement for further need has to be satisfied. And in my research for submission, from these documents which he had placed on record, which has been verified, absence of follow-up requirement. Rather, follow-up was required and not availed of, itself shows that there was no further. Now, one aspect is about this medical condition, which in my research submission there is no further. Second aspect of age. Age also we cannot discuss that age. But age by itself will not be a ground for an convict to ask for an interim bail. Age coupled with medical condition, one can ask for interim bail. Now there are other convicts also in the prison of Gujarat who have crossed 85 years of age and they are still in jail. So merely simpliciter age would not be the criteria to consider him for an interim bail. And as there is no need, I would respectfully submit that this bill may not be accepted. And the rest of the treatments he was already getting, as and when it is required, he was already getting those treatments in jail.
Request your lordships to turn to page 218. It is a chart from 14th to 23rd January 2025 of Jodhpur. Lordship may go to column 3. Blood pressure 140/90, 126/80. સવારે અને સાંજે વેરી રેગ્યુલર બ્લડ પ્રેશર. મારું બ્લડ પ્રેશર આટલું નથી આવતું અત્યારે, 150 અને 85-90 આવે.
તો કોર્ટમાં શું કેવી રીતના આવે?
If he is a heart patient and a serious ailment, blood pressure can never be at this level, and it is continuously, my lord. Next page also. Lordship will find from 24th January to 17th February. 136/90 in the morning and 130/80 in the evening. But looking to this condition, the Supreme Court has granted him, he has taken the treatment to various places, Ujjain, Ahmedabad, Jodhpur, other places. And whatever treatment he was taking or he wants to take, certain treatments are such that they can be taken in the jail also. But it is not necessary for that he should be on a temporary bail. The arrangement, the jail is making the arrangement. Secondly, my lord, in a Jodhpur, he is getting the treatment from AIIMS, not ordinary hospital. So in these circumstances, my lord, it is not a fit case for now extending the temporary bail.
Just 3 minutes.
No, before my name, only one of the statement, if my lord can have second statement of that, who is endocrinologist of Delhi. What he states is, જેના માટે તેમને એકદમ પૂર્ણપતિ જે કમ્પ્લેન લઈને આવેલ હતા તેના માટે કોર્ટિસોલ હોર્મોન ઓછા છે તેવી હિસ્ટ્રી સાથે આવ્યા હતા. તેમની હિસ્ટ્રી પ્રમાણે તે હાઇપોથાઇરોઇડિઝમ તથા ડાયાબિટીસ તેમજ હાઇપરટેન્શન ની સારવાર લેતા હતા. હિસ્ટ્રી પ્રમાણે શરદીને સોડિયમ ઓછું હોવાનું કારણ અમુક આયુર્વેદિક દવાઓ કે જેમાં પાલો તેમજ આર્સેનિક હતું, પરંતુ એમના રિપોર્ટ્સ પ્રમાણે જે આગળ એન્ડોક્રોનોલોજીસ્ટે કરાવ્યા હતા તેમાં તેમનું કોર્ટિસોલ હોર્મોન નોર્મલ હતું. એમની ક્લિનિકલ કન્ડિશન તેમના તાજેતરના રિપોર્ટ્સ પ્રમાણે એમનું કોર્ટિસોલ, સોડિયમ, સુગર બધું જ નોર્મલ હતું. એમની રૂટીન તપાસ દરમિયાન સુગર બીપી નોર્મલ થઈ. તેથી પહેલાના રિપોર્ટ કન્ફર્મ કરવા મેં અમારી સેલની રેગ્યુલેશનના ચોક્કસ સમયમાં રૂટીન તપાસ દરમિયાન સુગર અને બીપી નોર્મલ હતા. પહેલાના રિપોર્ટ કન્ફર્મ કરવા મેં અમારી સેલ્ફી લેબોરેટરીમાં ચોક્કસ સમયમાં અમુક ટેસ્ટ કરવાની સલાહ આપી અને એમની રેગ્યુલર દવાઓ ચાલુ હતી તે ચાલુ રાખવાની સલાહ આપેલી. મારા તરફથી મારી તપાસ પરથી એમને કોઈ તાત્કાલિક સારવારની જરૂરિયાત જણાય આવેલ નહીં કે રોજિંદા જીવનમાં કોઈ સુગર અને બીપીની સંભાળ બતાવેલો. દર્દી સ્વયંસોની મેં કરેલ તપાસ મારા તરફથી બીજી કોઈ દવાની કે કોઈ ટ્રીટમેન્ટની જરૂર લાગેલ ન હતી. જેથી મેં એમની રૂટીન સારવાર ચાલુ રાખવાની સલાહ આપેલી. થાઇરોઇડની દવાનો ડોઝ વધારવાની સલાહ આપેલ હતી, પરંતુ તેઓ તેમના પર્ટિક્યુલર પેશન્ટ થાઇરોઇડની દવાનો પહેલાની ડોઝ ચાલુ રાખવા માંગતા હતા. સારવાર કરો ભવિષ્યના ટ્રીટમેન્ટ માટે બીજાને કરી શકે છે. But this is how the reports stand. Therefore, in my research, there is no.
The reports are not showing such a precarious condition that he is required to take the treatment outside the jail. If the position is precarious and it is difficult to get the treatment in the jail, then it is understandable that he may be granted the temporary bail. But it is not so.
This point first, last point first. If your lordships again have the page 18, I didn't read these two paras. This is exactly what the learned Solicitor General argued in the Supreme Court. Let me read this. Learned Solicitor General appearing for the respondent submits that though the ailment is not in dispute, today they might even dispute the ailment, but the ailment is not in dispute. So also the age, treatment can be extended in the prison itself, which the petitioner is reluctant to undertake. In any case, considering the facts and circumstances of the case, adequate security will have to be provided to the petitioner. It is further submitted that on merit, the petitioner does not have a case. So exactly this argument. Supreme Court, again, I read this page 19. We have no hesitation in holding that the petitioner does require interim bail on medical ground. Till 31(3) at least is given. There is also some suggestion of lifestyle changes. Lifestyle changes. Now, my lord, just to answer the learned PP, my lord, just 3-4 things, my lord. I agree with him that since the last line Supreme Court says that we have to approach the High Court for any further need on medical ground, but I have to show need. My submission is, my lord, that therefore I have placed on record 19, 2 and 22, pages 176, 179, 198, all the 3 pages, my lord, where if your lordships were to see again, my lord, there is advice. Yes, I can understand if my learned friend, my lord, through their experts or through their verification say that these reports given out by MGS, MJM Medical College, Indore are disputed or unreliable. That's a different thing. Otherwise, if your lordship sees it requires specialized nursing care and close monitoring, regular visits to physician, cardiologist, avoid undue excretion and stress, regular follow-up with endocrine nephrologist. These are advices. Therefore, my submission is that when my learned friend says need, the need is clearly shown after 7/1/25 by these reports of otherwise, what can I do? What else can I do? I have to go to doctors on my own. If I file affidavits upon affidavits and say that I need this, the court will not believe me. The court will say you to go to experts. And who are the experts? The doctors. So, I have gone to those concerned places and got these reports of 19.2 and 22 which clearly suggest a need. Now, as I said, my lord, if my learned friend says that the reports are unbelievable, they can't be verified, or there is some problem with the reports, that's a different thing, my lord. Then your lordship obviously will consider that not to take into account these reports. But if the reports are what they are, and they say what is actually required, my lord, my submission is that then this argument of I have not been able to establish need, my lord, may not be correct, my lord. So that's one submission. My learned friend mentioned about page 164. That's important because it's AIIMS. This is no private hospital, AIIMS Jodhpur. My learned friend, this is the 164 is very important because this document talks about lifestyle changes. Now here, my learned friend's argument is that it's not signed by anyone, so we couldn't verify, Lord. Okay, I'll just give a copy. This is the original. The same wordings. It's a type. What I've given is a type version. The same are handwritten, and this is if lordships may just have a look at this, this, and this can be verified also, but it's signed. The same original report, page 164. Maybe in a hurry. We have not placed that on record, but this can be verified. I'll give a copy will be shown to my learned friend also, so that. But it's signed. Definitely signed. So that controversy can be laid to rest, my lord. My learned friend can be shown a copy, will be original, so that he can also verify this. Thirdly, my lord, my learned friend says that age alone is never a factor. My lord, I have not argued that. I have not argued 86 years after having done jail time of more than 10 years. I have not even argued. I have not argued that because he is 86. Supreme Court could have also turned it down. Supreme Court, there was no question of granting bail for even these 2.5 months. If age was the only factor. The Supreme Court has said in the first line or in the later paragraphs that this is the fit case for grant of interim bail on medical ground. So I have come to your lordships on age and the issues and the serious issues, serious fatalities. Fourthly, my learned friend Mr. Nayak just mentioned how he can get all this treatment in jail. That is exactly what the learned SG argued before the Supreme Court. Despite that, the Supreme Court said, no, 31(3), and you go to the High Court actually if you have any other need. So that also, this argument was available and it was made. But the Supreme Court said, no, otherwise the Supreme Court could have said that there is a question. The prison is all you have and everything is available there. Also, my lord, I don't think my learned friend PP is entirely correct when he says that, okay, need can never be Ayurvedic treatment, my lord. If the parliament, if the government of India recognizes Ayurveda and Unani system of medicine as a treatment, as a course of medicine, my lord, there is a question of arguing that only allopathy, my lord. And, my lord, this is common, as I understand, my lord, the judicial notice can be taken of the fact that we don't do invasive surgeries of people, my lord, who are 85 or 86, my lord. It's not easy. There can be, my lord, supermen who can even take needles at the age of 91, but this person doesn't appear to be a person like that, because not one report, multiple reports say that not possible, invasive surgery is not possible. Here, and the blockage is actually more than 90%. Page 33, in fact, I didn't show it, Lordship, the blockage, I believe he has 3 blocks, 90% blockage. So what is the question of invasive surgery? And last point, my other friend said, he never came for follow-up. Actually, in Ujjain, this was in Ujjain, we were very much, we didn't run away. We were, yes, we went there on, I believe in the month of March, 3rd or 4th March, we were there till 17th, 18th. That is how this treatment started, after 18th. We were very much there. We were taking, because there is a doctor, who is constantly with him. So it's not that, okay, we went there and then the doctor said, okay, you come back, and we never went for, so never went for follow-up, was I running away? Have I become suddenly better? So, the submission is that with all this material on record, my request to the court is that, and if this is the only treatment which I can actually get, Panchakarma, because otherwise nothing else works. Allopathy doesn't work. Invasive surgery doesn't work in this case, and if Unani and Ayurveda is treated to be, a lot of people, in fact, this again judicial notice can be taken to the fact that a lot of people do take the such treatment, and they are all available, and that is why it's recognized. It's a system of medicine which is recognized. I can understand, that I come up with some voodoo system. That's a different thing, but it's not. Yes, madam. Yes, madam. Yes, madam. Yes.
When Maharaj can be sent there for Panchakarma or other.
Panchakarma, yes. Yes, madam. Yes, madam. So, true, madam. So that's what I'm saying, that if I come up with a voodoo system of medicine, I suppose some kind of healing where you have these people, so demigods, all that's understandable. I'm not in that. This is a recognized system of medicine, and I think I have been able to make out a case that this man cannot take a needle. He's 86 years old. In that context, I beseech your lordships to consider his application for extension. Oblige.